Hi everyone, we're really excited to have you at Tranche Two Unlocked Tech Solutions for Modern Accountants. Before the event, we thought it would be helpful to send out a video on exactly what the Tranche Two means for you. So today we've got the wonderful Fiona here to explain the new reforms for you.
Great. Yes, it's the new development for many accountants. There's going to be a lot of new obligations, and it's important to think of how you'll be able to satisfy those obligations, because unless you've already been part of the regime, and there are some accountants who have through different ways, but unless you've already been part of the regime, from 1 July 2026, there's a very strong chance that you're going to have to consider AML obligations in your practice. So it's a good time to start thinking about it. We think that you'll have to really start making moves in this area certainly by the beginning of January. And so without any further chat, I'll just hop into talking about these new provisions and what they're likely to mean for you. So the reforms are part of the AML-CTF Amendment Act, and that was passed at the end of last year. And then there were rules finalised in August this year, and then we've had some core guidance recently. Other materials are still being released. We're expecting all kinds of materials being released during 2026. So what this new regime does is it extends obligations to lawyers, accountants, and other professionals who provide designated services. And that's a word that's really important. And we're going to talk about that in a minute. These new occupations are Tranche 2, and these changes are brought in to align with international standards and the FATF recommendations. So FATF is an international body, and it's a voluntary body that governments around the world sign up to. And Australia was actually one of the founding members in the late 1980s. But since that time, Australia's work in terms of countering money laundering and terrorism financing has actually dropped down. And we were in quite significant danger of being grey-listed in this area as a result of an international evaluation which was carried out in 2015. And that's significant because there are lots of people who are saying, oh, look, these changes can't possibly come in by 2026. We haven't had enough time to get ready for them. But in my view, there is absolutely no chance that there's going to be any extension of time on this, because the next international evaluation is in late 2026. And it's extremely unlikely that the federal government is going to have another situation where we have an international evaluation and Australia is grey-listed, because that would have major consequences for all kinds of international trade. So I do hear people talking about how this isn't going to happen. I just think there's just no chance about that. So the key dates are the Act was passed at the end of 2024. From the 31st of March 2026, there are new rules for a lot of the Tranche 1 entities. Okay, but if you're an accountant, you're likely referred to as a Tranche 2 entity, and your enrolment will open on the 31st of March. By the 1st of July 2026, if you're going to provide a designated service, then you have to have an AML-CTF program in place. So who is affected? The Tranche 2 entities are largely lawyers, accountants, real estate agents, trust and company service providers, conveyancers, business brokers, if you provide a designated service. And that's we'll talk about in just a couple of minutes. And so if you are providing a designated service, then you must enrol within 28 days of providing that service. Once you enrol, then you become a reporting entity, and there are lots of obligations which will apply to you. Those obligations are that you will identify your clients and beneficial owners when you're providing or before you provide a designated service. You will report on suspicious matters in some circumstances, generally if you're providing a designated service, you have to have an AML-CTF program in place. That's quite an obligation. And you will be undertaking regular reporting to AUSTRAC. The first general report is going to be due in early 2027. So you can see there's not a lot of wriggle room here. One of the significant issues to appreciate from this new regime is that it's all about process, information collection and records. No one's actually expecting you to stop money laundering. What they're expecting you to do is go through the process of identifying people and reporting and having a system in place for ensuring all of that happens. So it's all about this, and so much of the world seems to be now about compliance. This is all about that. So what is a designated service? And as I mentioned, this is relevant for a number of reasons. The first is that if you're providing a designated service, then you must enroll. And so that's the most significant, that's the biggest point, because that's a huge fork in the road effectively. And there's quite a lengthy section that covers what is a designated service. And it's much too much to fit on a slide, or even a number of slides, really. Now, I know that as an accountant, you are used to detail. And when I put this quite broad slide up, your head's going to be going, well, what does that mean? If you'd like a copy of Table 6 of Section 6 of the Act, which sets this out on one page of a very small font, you can email me and we'll send it to you. But in broad terms, it means acting for or assisting clients to buy or sell or real estate, or a body corporate or a legal arrangement. And legal arrangement, I've covered on a later slide, but it generally means trust. It means almost anything that's a entity or a business structure. So it means, for example, it's going to be a trust, if that's established by law, except a testamentary trust is not included, partnership, joint venture, unincorporated association, all kinds of structures. If you are creating or restructuring companies, trusts, or other legal entities, and many accountants do that, an absolutely critical one is going to be providing a registered office or business address for a client. And if I was running an accounting practice and I was just doing compliance work and I wasn't doing any of the other activities, which are going to be designated services, I'd be thinking very carefully about whether I'd be providing registered office or business addresses, because you don't want to just click into this regime for something like that, which you probably don't make any money out of anyway, or any real money. Managing client money, property or digital assets, acting for, assisting with capital raising or lending arrangements. And then the final one, you actually have to read really carefully. It's acting as or arranging nominee directors for another person. It doesn't mean just acting as a director. It means it has to be one step removed. There are some exemptions, and you can see from the exemptions, in fact, when you look at the exemptions, you can see how narrow they are. And it's the narrowness of them which shows you how broad this whole regime is going to be. Things subject to a court order. So that's a bit like you may have had some exposure to court orders, for example, to transfer property as a result of a family law dispute. So that kind of order. Transfers for deceased estates, because even AUSTRAC appreciates that dying is too great a step for most people to be involved in money laundering. Testamentary trusts, drafting powers of attorney for a natural person, not a company. So if you're doing a corporate power of attorney, that's captured. So you see, they're very narrow, these exemptions. So if you are doing any of these designated services, then you have obligations. Those obligations are: you must enrol within 28 days of providing a designated service. The enrolments will be open from the 31st of March 2026. And that is something that you don't want to, I wouldn't be delaying too much on that, because one of the things that's happening here is that we are going from a situation where Australia had around 15,000 reporting entities to where we're going to have 90,000 reporting entities. And you can just imagine what it's going to be like in AUSTRAC's computer system when there is this scale of enrolment happening. And I'm sure they're hoping it's all going to work on the day, but in the last few days of June 2026 and the beginning of July 2026, if that system holds up, it will be surprising. And any of you that have had much experience with the ATO portal will be no doubt shaking your heads and thinking that this is going to potentially be problematic. It's important to have a compliance officer, and this is part of the international structure. And if you look at the international rules on, or the international recommendations on AML, it's always very important within those to have a compliance officer. The idea being that there should be one person who is absolutely got the responsibility for it. Now, they don't bear the ultimate responsibility in many ways because there are also important roles for the governing body of an organisation, and that in a company would be the directors. And then there's also an important role for a senior manager. Now, if you're a one-person firm or a small firm, and you are listening to this and thinking, oh well, this can't apply to me, it does apply to you, but you're expected to wear a lot of hats. So you'll be expected to be, you'll be the governing body, you'll be the senior manager, and you'll be the compliance officer. And that's pretty well documented by AUSTRAC. So if you are a sole practitioner, you definitely will be wearing a lot of hats. The compliance officer within a larger organisation must have authority at management level and access to resources. They can be on staff or they can be a contractor. And we're expecting that there will be quite a number of people who will put their hands up to be an AML-CTF compliance officer for hire. That's certainly happened in the AFSL space, where there's always been responsible managers for hire. And AUSTRAC is quite clear about the fact that that can be acceptable, provided that person satisfies the other criteria. And there are a number of criteria. I just mentioned as part of this as well that this video today is just an overall informational summary. So you shouldn't act or fail to act as a result of anything that I say today. This is informational purposes only. You will have to have an AML-CTF program, and this is part of a new way of it's a trend really in international compliance, and that trend is to move to a principles-based regime. And that means that instead of the government giving you really detailed prescription, what they do is they do a big picture thing and then tell you that you've got to work out how to comply with the law. And that's pretty well what they've done here. That's going to be pretty interesting for a lot of people. And a lot of people are going, well, how on earth am I ever going to do that? We're very busy writing policies for people. This whole regime is based around policies. So you're supposed to have a program, and that's going to have policies, procedures, governance, and those policies are effectively get to have the force of law. And the reason for this approach is that it's seen that organised criminals are very good at getting around the law. So, for example, if you make a rule that says that you have to report every transaction over $10,000, what happens there is, of course, every transaction is then $9,000, isn't it? So the idea is that you, as the reporting entity, have to put in place policies to ensure that you're dealing with your risk. But then, once every 3 years, you're going to have an independent evaluation. And that evaluation will be about whether your policies are up to scratch and whether you're complying with them. And that in itself is going to be very interesting because you remember that earlier I said that there were previously 15,000 reporting entities, and now they're going to be 90,000 entities, there's going to be a place for an awful lot of new independent evaluators. And there's been discussions about, and this is the one area where potentially there might be some movement with timing, and that is whether these evaluations can be somehow staggered, because everyone is starting from the same date, which means we're going to have a huge lump of evaluations every 3 years. So that might be an area of some movement, perhaps. You must ensure your staff are trained and aware of their obligations. And we're seeing at least 3 to 4 levels of training happening in the entities, because there'll be different levels for different people who do different things. The idea is that a program should reflect the nature and size of your business, and you don't want a non-tailored policy. You want a policy that fits with your business, because later on, at the time of valuation, it's going to be checked as to whether you're complying for that. So if you are, for example, a small firm and you take on and you just grab a policy from somewhere which applies to a firm which has got 50 people, it's very unlikely that you're going to be following that regime. And that's when you will really get into trouble, when you are not following your own policies. Conducting risk assessments is going to be important, and you have to assess the risks associated with your business. So and a classic example of this is, so say for example, you are an accounting firm in country town, you know all your clients, you've known them for years, the kind of work you do is doing, domestic work. This doesn't seem to be any risk factors, very low risk factors. Compare that with, for example, a firm that does remittances to Afghanistan. They will have a much higher risk profile. Okay. So you have to go through this process of considering your risks, and then you use that and you go, okay, what should my program look like? How do I manage this? So for example, if you're the farm, if you're the country accountant, then you can actually, you can see your clients. You get a new client, you can easily identify them. They can show you physically their driver's license, that kind of thing. You can verify it. They're probably going to have a name that matches up. Much easier, much more difficult if you're conducting business with people in Afghanistan. That's going to be a very different thing, and your risk assessment will need to follow that. Well, your risk assessment will show that and then lead through to the processes you have to have in place. You also need to conduct a risk assessment for each new client. So you're looking at that where you're providing designated services. And there are some clients that are high risk and they need to have enhanced due diligence. You also will be conducting initial and ongoing customer due diligence. And part of this is you need to be, as part of your due diligence process, you need to identify who are the beneficial owners, and you will be looking for, and this will be a new phrase to most of you, politically exposed persons. So you'll need a system for identifying who is a politically exposed person. And in broad terms, a politically exposed person is a person who could be subject to a bribe. I think that's the easiest description. They would include people who are at a high level in the military, judges, government officials, mayors of local councils, that kind of thing. So there's lots of different things. And there are different risk factors for domestic politically exposed persons and overseas exposed persons. You also need to check that none of the people that you're working with are subject to sanctions risks, and you need to verify their identities. And then you need to maintain records of this for at least 7 years after the service is completed. And this is where a lot of firms have gotten into trouble overseas, is they know they've done the customer due diligence, they just can't find it when AUSTRAC comes knocking or something goes wrong. There's also, you can see when you're looking at this, that this is going to require new processes in terms of how you're going to do this. We've only just started within our own firm having to think about sanctions much, and it's a whole different world. So you'll need to think about that. For high-risk clients, you're expected to undertake enhanced due diligence, but you'll need to be able to work out who is a high-risk client in relation to that. There are some situations when you can get information from other reporting entities. So, say for example, you've got a transaction going on, and there's a law firm involved, and there's you involved as well, and you're thinking, well, do all of us have to get all of the information? The answer to that is potentially no, but it's pretty difficult. When we've looked at this, you have to have a written agreement with the other entity. You still have to undertake CDD, it's not quite as onerous. It's quite tricky, this. So I think that in most cases, I don't think I think in many cases you won't be able to get out of doing this. I think at least in some level you're going to have to do it in designated services for new clients going forward. Now, you've heard me refer to new clients, and there's a concept of pre-commencement customers. For pre-commencement customers, I will say this is really complex. The law on this is really complex. But I'm just giving a really broad brush here, and that is that you don't have to undertake initial client due diligence on a pre-commencement customer. So that's a customer you had and were doing services for before 1 July 2026, unless you have to report a suspicious matter on them, or there's a significant change in the nature or purpose of the business relationship, which makes the risk change. So but in general terms, I say that as a starting point, I just make the statement that it's very unlikely that you're going to have to undertake CDD on all your existing customers. So that's a relief and a big question for a lot of people. Now, there are reporting requirements, and one of those is to submit your annual compliance report, and that's the one that's going to be due in the early part of 2027. So you have to report quite a large amount of information to AUSTRAC. The next thing that's interesting to people is that you need to submit suspicious matter reports. And that is when you become aware of matters which are suspicious, effectively, and that is when you commence to provide a designated service, and that information may be relevant to the investigation of any offence, or you also are thinking that the identification you've done of someone, it turns out that the person you thought you were dealing with is not the person you were dealing with. The time frame for making these reports is really fast. So it varies a bit. So if it's anything to do with counter-terrorism financing, it's 24 hours. Anything else, it's 3 business days, unless there's a legal professional privilege issue, and then you get 5 business days. You also are not allowed to tell the customer about this if the disclosure of the information would be expected to prejudice an investigation. That's a bit of a change. It used to be that you just weren't allowed to tip off. I think this new change actually makes it more difficult, because I'm thinking, I don't know about you, but most people don't know very much about investigations at all. How would they know what was going to prejudice an investigation? So you say, what is a suspicious matter? Okay, these are some red flags, and there's actually a really terrific summary of red flags on the website of the Law Society of Queensland, if you'd like to see any more of these. And you can see these are the things that really you go, well, this all doesn't look right. So you can see that list there. One thing is that it's not okay for someone to come and see you and look as though they're going to become a client, and then as during the process you become concerned, and they obviously and you say, no, we're not taking you on as a client. That doesn't stop you having to make a report about them. Okay, so that's a useful thing to remember. So it'll be helpful if you can integrate this new AML requirements into onboarding, and to try and do this as smoothly as possible, because it's got the potential to be a pretty high aggravation point for new clients. And so you do want to make this work as well as you can and have the system working. I mean, you don't want a situation where 2 weeks later the client still, is still waiting around going, well, am I going to become, can we go forward or not? You probably want to be able to do this pretty efficiently where you can. So you'll need to, there will be a question of balancing confidentiality and compliance. One thing that's going to happen here, which will be significant, is that AUSTRAC tells us that in May and June next year, they'll be conducting a publicity campaign to tell basically the Australian public why their accountants, lawyers and real estate agents and etc. will be seeking further information from them. And so hopefully that's effective. So, but I'm not sure how much. It would have to be a huge, absolutely huge process to be able to do that, to get that across to the general public. So we'll see how that goes. One thing you might want to think about, though, is you might want to think about now, any new clients, you might want to think about amending your engagement letters. Definitely you're going to want to have some new wording in those going forward. Risk management tips. Identify which services you've got under the AML laws. If it was me, I would have a really good look at what services your firm provides and how much money you make out of those different services. Our rule of thumb is if you're making less than 25 grand a year out of designated services, we'd suggest you look at whether that work can be outsourced to someone else, because the amount of messing around that you're going to have going forward will be significant in terms of being part of this new regime. And you only need to provide one designated service to be in the net, okay, just one. So you don't want to be doing a job for, and some of those jobs are hardly worth anything to you. And whether you want to keep providing those services and have to deal with AML, the AML regime would be a really significant question. Now, penalties and enforcement. AUSTRAC, to my mind, is probably the second most financially successful government agency after the tax office. So for what is a very small, it's a pretty small organisation. And when I say this, when I say it's only, I understand that its annual running fees have to date been around the 150 million mark, which sounds like a lot of money, but it's not in comparison with government departments. It's really small. But what has happened is that when the original AML Act was written in 2006, it was structured so that every single day that you don't do something, it's another offence, okay? So you don't do a report on day one, it's an offence. You don't do it on day two, it's another offence. And that's how you get to these absolutely eye-watering amounts of penalties. So the largest civil penalty to date was Westpac for 1.3 billion. And that was because Westpac had breached the Act more than 19 million times. And my understanding is that this was actually a negotiated penalty. And my understanding is that it was, they were actually looking at 19 billion to start with. Okay, so serious money. But it's more likely to be around 20,000 for small entities, but they are very enthusiastic, and you don't want to, I suggest you don't mess around with them. What they have said is that they don't expect that for, entities providing designated service, they don't expect you to have perfection at the moment, but they do expect you to have your policies and systems in place and to have made a real effort to comply. But they are definitely looking for policies, systems, compliance officer, that kind of thing. So it wouldn't be a presentation by a lawyer without a legal disclaimer. I just say, I've mentioned this on the way through, okay? But if you would like, I did mention that if you'd like a copy of Table 6, to get in contact with me, and my email address is fiona.halsey@halseys.com.au. Thanks for being part of the video today. And I look forward to seeing you at the presentation. Thanks. Bye.